Hi, good evening, everyone. I wanted to thank you all on behalf of Pennsylvanians for Modern Courts for joining us for tonight's presentation, and thank you to Pam from Chester County Library for hosting us tonight. On the next slide, we will have a presentation questionnaire. You can hold up a phone to scan the QR code, and filling out these surveys is an essential way that we receive funding to continue putting on programs just like this one. And you'll also be entered in to win a raffle for the opportunity to win a Starbucks gift card at the end of the month. And for those of you who do not know, I'll provide a quick introduction to Pennsylvanians for Modern Courts. We are a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, fairness, accessibility, and respect. For over 30 years, PMC has worked to educate all Pennsylvanians about our courts and how to navigate them with confidence. PMC aims to provide resources to make that possible for all residents of the Commonwealth. We will not be offering legal advice tonight, but we still hope that all the resources we're providing will be an informative and educational experience for everyone here. And we are very, very honored and thankful to have our very own CEO, Debbie Gross, and Brian Gordon joining us tonight. Debbie is the CEO and president of Pennsylvanians for Modern Courts, and she comes to the organization with over 35 years of private legal practice. And Brian Gordon is a lawyer who has extensive knowledge in estate planning and how to administer an estate, and we are very, very thankful to have them both. I'll pass it over to Debbie.
All right, thank you, Lucy, and everybody. Thank you for coming. Welcome. This is we will make these PowerPoint slides available to you afterwards. We'll get your emails from Pam, or I will forward this to you. But this is just a sample of our upcoming programs. This is part of this series. I'll say this estate planning series is a two-part series. We talk about here how to probate an estate, but we have a partnership with Chester in December where we're going to discuss necessary papers. And that we also have an upcoming benefit, which is November 20th. So everybody knows you're welcome to join us. We are honoring the first female judge on the Superior Court, Judge Phyllis Beck. She's also one of the founding reasons, I'll say, or reasons that the PMC was founded, because she was the chair of the Beck Commission report, which was created after a scandal in our judiciary, and recommended that we have merit selection, which we don't yet have after 35 years. So that's a whole nother story. But I do hope everybody did go out and vote yesterday, because judicial elections are important. Okay, I'm going to skip this. Brian, I'm going to pass it to you. I want to thank you very much for joining us. Brian has joined us before. He is a wonderful person to work with and a great attorney. So thank you, Brian.
All right. First of all, thanks for having me back. It was a pleasure to present last time, and I'm hoping to give a really interesting, practical talk. You can use the chat, but if you have a question, you want to raise your hand. I don't think we're that many people that I can't take a question. I'll try to keep some time at the end. Debbie, how many minutes do we have?
It's an hour, so I can even stop just you at 7:25 or 7:20 if you want,
Okay, that'd be good. So the three, in addition to kind of a mechanical review of how you administer an estate, I want to cover a couple of issues with you that I'll probably hit along the way, but if I don't, I'll come back to them at the end. And one is, attorney's fees and how to reduce attorney's fees in estate administration, or what are the activities you can do yourself and which ones do oftentimes people need an attorney to have an assist. Secondly, how to avoid conflicts in estate administration with your family. This is sometimes really difficult. And part of it is who's chosen to be the administrator of the estate. And the third is to talk about the complexity, about what's essentially important about estate administration. And for example, and how complex does it be? So for example, if you have an estate involving a number of bank accounts and property that gets sold and number of expenditures and fixing up costs, you need to hire an accountant or a lawyer and spend, gobs of, $5,000 or so on an accounting, or is it something you can do yourself? And the argument I would have is depending on the ability of the people involved and the personalities of the family, oftentimes there are things that you can do in account. If you can state what came into the estate, how much was spent in the process, and what you have left, and if your family has confidence in it, you don't need to spend more. So that's just one quick point I wanted to make. We're going to go through some of the basic mechanics of estate administration. These days, the landscape has changed a little bit. In the olden in the times when I first started practicing, I was about to say the old times. Most people had their money in individual accounts in their name, or if they had a house and their spouse had died before them, then the house is in individual name, and that's still the case. So wills mattered a lot more than they matter today. Nowadays, a lot of wealth is created and accumulated in retirement accounts, and retirement accounts are governed by an employment retirement statute that's as thick as a phone book and has something called beneficiary designation forms. And those are that they don't pass through an estate, they don't pass through your will, they go directly to the beneficiary. So increasingly you might see 70% or more of the assets of an estate go through beneficiary designation forms, and only a smaller amount being assets in the individual name of decedent. The other big trend is pay on death accounts, and these are bank accounts or TOD accounts, transfer on death. And these accounts also obviate the need for estate administration because when someone dies, the money goes directly to the beneficiary. So there's an effort to sort of, and it's very easy and it's fast and it doesn't involve the complexities of an estate. So it's very popular, increasingly popular mode of transferring wealth from one generation to the next. So let's get going with the PowerPoint. The Register of Wills is also the clerk of the Orphans Court. There's a Register of Wills in each county. Oddly enough, it's an elected office. And in Chester County, Michelle Vaughn is the Register of Wills, and their address is on the screen. And you can, if you forget the address, you need the phone number, you just Google Register of Wills, you type in your county, and it'll pop up and you'll find it. So you can, I use Google a lot increasingly just as a phone book at times. The Register of Wills is where you go to probate an estate after someone dies, and probate means open an estate. So there's really two ways you probate an estate. So for example, suppose you have a piece of property that was owned by a husband and wife. Suppose husband dies first, it's then owned solely by the wife. Well, the only way to get the power to transfer that property is to open an estate. There are two ways to do it. One is by offering a will into probate, and the other is, if there's no will, to use the will that's written into the statute called the intestate scheme. So an estate, we have the definition here: an estate is all the property and obligations of a person who is alive or dead for our purposes. The person died as the decedent. The probate is the process of opening a file with the Register of Wills and having an executor administrator appointed by the Register of Wills. And why is this important? The best way to view this is that the executor or the personal representative or the administrator, if there's no estate, what they have is they stand in the shoes of the person who died and have almost the same powers as the person who died to transfer assets and move, as needed into an estate account. And I'll talk about the process in just a minute. So the first question is, do you need to probate an estate? And I've been kind of trying to address that issue so far in this talk. If you have real property, if you have personal property in the individual name of a decedent as opposed to a pay on death account, you need to probate an estate. It's the only way to move those accounts and to liquidate them and distribute them to pay the debts and distribute them to beneficiaries. Or if you have probate property, property can only be transferred by going through probate. Non-probate property is property that passes outside of probate by other designations, such as jointly owned property, jointly owned accounts with named beneficiaries, life insurance policies. retirement plans, and also retirement, IRA, 401k, and other accounts with beneficiary designations. I find this chart a little confusing. I went through it earlier. My preference would say that if you have an asset that's, you get the monthly statements of the person who died, and you're assembling them to get a handle on what's in the estate, and you make a list of these, which is an early, one of the first things you should be doing.
Well,
And you look at the titling of the account. If you see the account is in the name of the individual person who died, then that's an estate asset. On the other hand, if it's a joint account, the joint account is presumed to be co-owned by the survivor. There's a whole separate series of issues. We may have time to get into that later with joint accounts, but I want to keep moving forward. A lawyer is not legally required to probate an estate. Some counties have gotten really easy for this step. Even where I'm representing someone, I would often send them in to the Register of Wills office with the right documents to do it themselves, because you don't even need a lawyer. For example, Delaware County in media, their Register of Wills office is absolutely customer friendly. If you go in with an original will, an original death certificate, and a driver's license and a check, and you are the named executor, for example, if it's a simple situation, they'll take care of it, and they'll fill out all the forms for you. Also, interestingly, Philadelphia, they will fill out the forms for you unless you have an attorney. If you have an attorney, the attorney has to go through kind of an hour or hours long process to file online. So sometimes I'll even send people into Philadelphia if I can, if it's simple enough. Having a lawyer assisting with the estate administration is helpful because they have knowledge and experience. There is neighborhood legal services for free assistance. There's one kind of estate that you really need a lawyer to help you with, and that is an estate in which the assets might not be more than the liabilities. In other words, the debts might be more than the assets. It still makes sense to administer those estates, but you really need a lawyer to help you through that process. And the lawyer can tell you things you might not know. Like, for example, if you administer that estate, you'll still get paid as a personal representative. A personal representative means either an executor, the will, or an administrator if there's no will. So if it's an insolvent estate or possibly insolvent estate, my strong recommendation is to go with an attorney, because it has to be handled more like a bankruptcy, and people get paid a certain number of cents on the dollar, and there are negotiations and that sort of thing, and the lawyer will really earn his or her keep for that. If it's a simple estate, there's maybe one piece of real estate, you're able to hire a broker and sell it. There's just a couple of accounts. That's probably the kind of estate you can do yourself. And if you get stuck, you can call an attorney, and the attorneys come kind of in two forms in terms of fee charging. Some charge a percentage. If you want someone to handle the estate soup to nuts, they'll often estimate a percentage or a flat fee to cover everything. And the other thing to do, you can ask an attorney, can I just buy a few hours of your time at a time? And a lot of attorneys like me would say, of course. And you can just use your attorney as a consultant to help you through the process. Let's see. There's a note here, there can be personal liability on an executor if not done properly. That is true. So, for example, if there's a creditor, someone the decedent owed money to, and they stand in line ahead of everyone else, there's a certain priority of claims, and you wind up distributing money to the beneficiary, and you didn't manage to see or weren't aware of all the debts, and you didn't pay the debts, there could be personal liability. It's one of several ways. So if you have questions, you should seek the advice of an attorney. Okay. Sorry, I'm getting, believe it or not, I'm getting over COVID itself 2 weeks ago, so I'm a little bit wobbly.
Oh my God, I'm so sorry. I didn't realize that.
It's okay. Much better than I was a week ago. Let's see. Payment of creditors. Oh, problem areas. So here are the problem areas. Payment of creditors. that has to be handled well. And I just want to say that a lot of times, whether it's you or your attorney, a lot of times creditors will reduce what they owe if you pay them right now instead of 9 months or a year from now. So a lot of times you can just pick up the phone and talk to the estates department of a credit card company, and they'll immediately make a deal, and you kind of reduce the bill, and it's all legal and proper. Okay. Never lie, of course. Don't say you don't have money when you do, but say, can I get a break if I am able to pay you quickly? But only pay them quickly if you know it's a solvent estate, meaning all the debts are less than all the assets. Medicaid claims. Medicaid claims can be super complicated. You should get an attorney. The issue of taxes we'll get to in a bit, and who pays the taxes and who pays the expense. These are kind of complicated things. Sorry. And okay. Types of estates, we went over this. If a decedent decide with a will, it's called testate. And there's an executor, because you have a last will and testament. And if a decedent dies without a will, it's called intestate, meaning there's no testament. And the next of kin, if it's an intestate estate, if you have, for example, 3 or 4 children, either all the children can serve, or they can decide who among them will serve. And then the ones who are willing not to serve as the administrator will have to sign something called a renunciation before the register of wills will appoint you or anoint you as the administrator of an estate. So, for example, if you have 3 kids, one is competent and wants to do a good job and wants to serve, and the other 2 are super busy, you can have the other 2 renounce in favor of the person who wants to serve, and it's as if they've been appointed. If they can't decide, if there's fighting and disputes and you can't decide, then you might have to file a petition with the Register of Wills. So it's it can get a little dicey. So the state laws of intestacy determine who. Oh, this is interesting. There's an order of who should administer an estate. So generally, it's the order in which one would take in the state's intestate statute, meaning the will that's written into the statutes. So the priority would be the spouse comes first if there's a spouse. And then if there's no spouse, it would be the children. And once again, you'd have to decide, are all the children going to serve, or are you going to have one or more among them serve? If there are no children, the parents can serve. If there are no parents, then the siblings could serve. And then it goes to the nieces and nephews. But at the bottom of the list, you can have a creditor of the estate serve. So if nobody administers the estate, and for example, you're representing someone who's owed a lot of money from the decedent, or you need to wind up a business transaction, or there's a partnership, then any interested person can file for and request letters of administration. So if nobody steps forward and someone has a mortgage on the house or other big, large debt, then what they can do is they can petition to administer the estate. Okay. Parts of the estate. Let's see. Okay, we've been through this already. This is such a good PowerPoint. It has everything I've already talked about, we've covered. Beneficiary designation estate. Those are the part of the estate that's covered by these forms. A joint estate, when we talk about that briefly, it's an interesting case. I once had this case where a woman befriended a 90-year-old woman who was a friend of her mom's in a nursing home, and she became her agent under a power of attorney. And she walked the woman into her various banks, and she had all of her accounts totaling, as I recall, about $450,000 in accounts. She had them retitled in joint name. And I wound up representing the charities that were supposed to receive that money. And what I discovered about the Joint Accounts Act is that there is a very strong presumption that if an account is in joint name, it was intended by the decedent to be a gift. And you have to prove by clear and convincing evidence that it was something other than that. Otherwise, the person who is a joint account holder gets to run off with that account. It's a real interesting area for mischief when you have frail decedents and people who have diminished capacity. So it's also an interesting area of litigation. So it turned out that the will was drafted by someone I know, my cousin, and she had intercepted this woman in the parking lot of the care facility just before the death of the woman, and she behaved in odd ways and said a few things that created doubt about the validity of that gift. So I was able to, representing 8 charities, I was able to get about 60% of the money back. So it was good. Anyway, interesting statute. It's a very, when you're doing estate planning, the joint accounts are accounts of convenience. If you have a child who's helping you to pay your bills, one way to open an account is a joint account with that one child. And if you have only one child, that's fine. It's actually a great strategy. But if you have 2 or more children, you might want to open a power of attorney account with an actual power of attorney, because that remains part of your estate and avoids this issue. Your probate estate. So there are specific gifts and there's a residuary estate. So when someone makes a will, if they wanted to give, suppose it's a estate with, $200,000, the person may want to give $10,000 to this niece or this nephew, or a certain amount of money to children, and then have the bulk of the estate go to their spouse or their children, and that's often done. What's interesting is the specific bequests, they're called, are priority gifts. So if the estate's almost out of money, only those gifts will be paid, and the residuary beneficiaries won't get very much. So you have to be careful about that with smaller estates. The residuary beneficiary is everything else. So when you're drafting a will, I like to look at it like a pyramid. You start out with things like personal property and individual gifts, and then at personal property, tangible personal property, then you go to individual gifts that you might want to give certain sums of money to people or to charities, and then you have the residuary estate. So it's like a sort of pyramidal structure. You can't give away the residue of the estate before you give away your individual gifts, because there's nothing left theoretically. So I've seen some backwards wills, and they were a little challenging. Probate basics. I think we covered this. The executor is a person named in the will. When there's no will, named in a will, or the decedent's next of kin, when there's no will, should gather the required documents. So if there's the first thing you want to do is see if there's a will. If there's no will, then you still need an original death certificate, renunciations from the siblings, and you can look up those forms or have an attorney assist you with them. And you need original renunciations, and you need a check or credit card to go on most registered wills now, and you need your ID. Thankfully, we're beyond the whole COVID virtual probate thing, because there were filings and refilings you had to do before someone went online with you, and we're fortunately done that. It's still available in some of the registered wills, but it's kind of an expensive procedure because it takes a lot of time to kind of pre-file everything, send the originals in, and then schedule these probate meetings. It seems easier just to go and sit down with a probate clerk and open an estate. Some places will prepare the letters testamentary or letters of administration while you wait, like Delaware County, and other places like Philadelphia will send it to you if you drop it in the mail a few days later, so you might have to wait a week. When can probate begin? So where? We already said this, the documents are submitted in person to the Register of Wills in the county where the decedent lived. This is important. You have to figure out where the decedent lived, and sometimes it gets a little bit confusing because they might be at a care facility for a brief period of time, and there's a question of where they really are residents of that county. And in some cases, it doesn't really matter as long as you pick one, but it has to be the same residence that is listed in the death certificate, or it's going to create problems. It's the first thing that the Register of Wills will do is to see where someone was a resident to make sure you're in the right county. When probate can get any time after the decedent dies, generally it's easier to probate as soon as possible after the date of death. You don't want to wait too long because taxes are owed 9 months after the date of death, and there's a discount on taxes 3 months. So you want to get moving. But you also, if you're, if you're in the middle of a grieving process, there's no obligation to do this right away. You can wait a month and start. No one, especially if it's just you or close relatives you get along with are the beneficiaries. Sometimes you need to move quickly, like if there's a house that needs to be insured, or if there is a business that needs to get going. And sometimes it's really urgent to move these along very quickly. In those cases, it would help to hire an attorney. So what are the steps? You find the will, and you determine who is the named executor by reading the will. Usually it's in the very beginning or the very end of the will. If there's no original will, determine who's the next of kin. There's an interesting circumstance here. If you have a copy of a will, and suppose it was done by an attorney many years ago, and it says it's a copy, you can probate a copy of a will if the attorney or a bank or somebody who is holding the original, lost it. So if you can prove that the attorney lost the original, you can probate a copy. Kind of important to know. So if there's no copy, no original, then you have to determine who is the next of kin. Is it the spouse, the children, the parents, siblings, etc.? Determine who's willing to serve as executor. That's important. If the spouse is older and lacks and is of diminished capacity and isn't very good with numbers, you might want to have a child step forward. Anybody in the family, and even a family friend, if everyone agrees, can serve as the administrator of an estate. Or if there's an executor who's named and they're not able to serve, everyone can agree on someone else, and that's important to know. Third, obtain a copy of the death certificate. Death certificate usually comes from the funeral home. So you want to ask for at least, depending on the number of accounts, I always identify if the person had 5 accounts, I would order 6 death certificates because each institution may ask for a separate one. So I'd always add 1 or 2, and they'll usually hand you 10 at most funeral homes. And the same applies when you're asked for the document proving that you're in charge of the estate. It's called a letters of administration, or something called a short certificate. It used to be a half a piece of paper, so they called it a short certificate. And in those cases, you want to get at least the number of institutions where you have accounts, because they're all going to want an original. Let's see. The executor must bring the photo ID to the Register of Wills. If you don't have a photo ID, they're going to make you come back. The commission. The commissions vary. They're kind of going up a little bit. So they might be on a small estate, an estate of, for example, $100,000, they might be, oh gosh, I'm not very good about this, but they might be, $500 or $600 in fees. But if you have a multi-million-dollar estate, that could be fairly substantial. So you want to be ready. You want to call ahead or look up online and try to figure out what the fee is for the probate fee. It's not large relative to the size of the estate. It's very small, but it can be a little shocking if you have a large estate. The executor administrator must submit an original will if one exists. We already went over this. Certified copy of the death certificate, estate information sheet, petition for grant of letters. That's the form that you fill out that pretty much tells them everything you know so far about the estate. Okay. Estate information sheet. It's the cover sheet for the petition. Use it for both intestate and testate estates, will or no will. Should be completed by the executor or the next of kin. It's a statewide form. And then the petition for grant of letters, frustratingly, especially during COVID, asks you all the same questions as the estate information sheet. I think it's pretty much the same. There might be like a phone number box or a fax number box, but they want to know how to contact the people in charge. So you fill this out, and with any complicated form, what I've learned in 30 years plus practicing law, you just fill it out. The form can look horrible. It can look daunting. It can look scary. And the key to big, long, scary forms is one box at a time. Just start out with the name, just read it carefully and start filling it out one box at a time. Pretty soon you'll be done. You'll be like, wow, I did it. Not that hard. Okay. Letters testamentary. We went through this already. Went through short certificates. Letters and short certificates give the executor, the administrator, power of the decedent's assets in order to, and this is critical, get assets and control over the decedent, access, like safe deposit box, and control of the decedent's assets, their bank accounts, their stocks, their investment accounts, deeding the house, that kind of thing. Once you have access to money, you can pay the outstanding debts. You can open, you'll have to open an estate checking account. I'm going to come back to that in a second. And then you distribute the assets to the beneficiaries or the heirs of the estate. So if there's no will, there's formulas in the state statute. So for example, if someone dies with a spouse and children, the spouse would get the first $30,000 of an estate plus 1/2 of the estate, and then the children would get the remainder split in equal shares. So let's keep going. So the basic steps of estate administration. One is you go to the Register of Wills and you get sworn in. That's when you bring these materials together and you present yourself to the Register of Wills. Sometimes some places you need an appointment. Increasingly, as we get further and further away from COVID, no appointment is necessary, but you should call ahead just so you know what you need to bring and you don't have to make 2 trips or 3. Once you get letters testamentary, meaning the power over the estate, they'll also give you a form notice to let the beneficiaries or the heirs know that you are administering the estate. This is a really important step in the issue as to the issue of fairness, because what you do is you send notice to all the people who are either beneficiaries in the will, saying you have an interest in this estate and here is the will. And they may say, well, that's less than I was expecting, or that's more than I was expecting. If it's more than they're expecting, you don't have a problem. But if it's a lot less than they're expecting, or if they think that the will is product of an unfairness or undue influence, then it could lead to problems. But you have to give notice. I think the time period is 30 days. I'd have to double check, be honest with you, about when that goes out. But as soon as you get it, if you can do it within a week, that's a great thing to do. And then there's a certificate, a second form called you certify that you gave notice. And that gets mailed into the Register of Wills with a list of the names and addresses of all the people who are beneficiaries. You advertise the estate. In most estates, it's a good idea to do the advertising. It's legally required. However, in very small estates, because of the cost of advertising, no one's going to I should probably hold up and not tell you to cut this corner. It's kind of complicated. If the person had 0 debts and was living in a care facility for years and years, and absolutely there's no creditors chasing them, you might want to waive off on the advertising, but that's not legal advice. I don't want you suing me down the road saying I could have avoided some debts. But the key benefit to advertising an estate, and this is, you need one newspaper of general circulation, which could be the Mainline Times, the Bucks County Courier Times, or the Inquirer. And you need a specialized newspaper, a legal newspaper, such as Legal Intelligencer. And the County Register of Wills will tell you the second newspaper you'll need to, or what 2 papers they'll suggest. And they have to be 3 consecutive weeks. And they have special department that sends you a copy of the little ad and an affidavit swearing that you that you are properly advertised. So once you get that done in the three ads in a legal newspaper and a general circulation newspaper, it limits the claims of creditors 1 year from the date of the last advertisement. So the sooner you get that done, better, especially if the person was, it's a good thing to do. If the person was active in business, if they were driving a car, if they had property where someone could have been injured, it's a good idea to advertise the estate in most cases. I think I'll leave it at that. And the register of wills or a lawyer can give you guidance as to how to do that. When you go to an institution such as Charles Schwab or Merrill Lynch or Wells Fargo, and you go to liquidate, or PNC Bank, and you go to liquidate an account, there's a reflex response I get from institutions that was different than when I first started practicing many years ago. They want you to open an estate account at their bank, even if you tend to open it and then close it right away. And then to open an estate account, it creates an additional step or burden. You have to get a tax ID number from the IRS. So I don't know, where am I on time, Deb? Where are we?
Good. You have still 20 minutes, at least.
Okay, I'm
Okay.
jumping in. I'm not looking at any questions.
That's okay. No
Let me keep
worries.
going. Good. Okay, so this is important stuff in terms of practical stuff. The IRS EIN. It's really hard to do at first. It's a one-size-fits-all document for getting a tax ID number, but you can apply online. And if you Google IRS EIN, I once got caught in this loop. Shockingly, there are companies that pose as the IRS, and they will charge a fee for what you can do for free. So you want to make sure you scroll down like 5 or 6 entries in Google when you ask for your tax ID, you Google tax ID number IRS, and you want to go onto the website that says irs.gov. Okay, super important, because why pay someone for something that's absolutely free? Okay, and then you go to the IRS website. You have to navigate through their pages. You want to scroll down to where it says begin application, and then you want to have the letters testamentary in front of you. You would need the decedent's social security number. You have to be the executor, or if I'm an attorney online, I'll often have the executor online as I'm running through this form with them. And it takes between 5 minutes and an hour to do, depending, because there are a lot of it's like a maze with different routes that you can take with dead ends, but it's not that hard. Anyway, you can do it yourself, but it's a little tricky. Also, the bank can help you with, the investment firm can help you as well. So step 5, and this is really important, is you want to make a list of all the known assets of the account. And so if someone's dead, how do you know what they have? And the answer is, and this is super important, you have to pick up their mail, and then you want to redirect their mail. Another reason to have an extra short certificate, you have to work with the post office to redirect the mail to your mailbox, right? And the reason is that you can figure out what they have, because they'll have monthly statements from every institution and every investment firm they work with. Or if it's an IRA, it'll be a quarterly statement. And if it's a stray asset, such as just a single share, a bunch of shares of stock, they'll get a K1 in the end of January. So that's kind of, you don't really know what they have until you kind of go through, at least through tax season, and you get all the K1s and 1099s, they're called, right? 6, you prioritize the debts. This is interesting. I had an estate that was close to being insolvent because the woman had a tremendous loan from one of these crazy schools. She actually had borrowed money from Pennsylvania Higher Education. But I saw in there's a statute that has what debts are the highest priority. And I found that medical bills within the last six months of death. Also, like an ambulance bill and that kind of thing. If the ambulance company was, like for example, Philadelphia Fire Department takes the person and sends a bill. Those kind of bills are priority debts, which means that you can pay them in full and not worry about someone snapping at you or at a later date saying, "Hey, you paid them, but not me," because you can pay them in full as long as you have enough money to pay all the priority debts. And then even if everyone else is, as they say in bankruptcy law, taking a haircut, if everyone's, maybe 50 cents on the dollar, you still have to pay the priority debts fully if you can. 7 is you do an estate inventory. That's a list of all the assets. So you want to identify all the debts, prioritize them, have the estate inventory. Then you want to file your tax returns, PA inheritance tax, your federal estate return, and your estate income tax return. So let me go through these quickly. Your PA inheritance tax return is almost always due. The only time it's not due is when you have someone survived by a spouse and everything goes to the spouse, because there is 0 taxes between spouses when a spouse dies. So if you don't owe tax, you actually, probably makes sense there are reasons to file the inheritance tax return anyway, but if you don't do it, there's no tax due, and it's kind of a no harm, no foul thing. The federal estate tax you only need to file a return if you're close to the federal exemption limit, which is now, I think, $11.5 million. So most estates don't reach the federal limit. If you have one of those estates, personally, that money coming to you, good for you. If you're an attorney, good for you as well. But they're kind of rare. But it's a complicated form called a 706 return. And it's been years since I filed them because only about 400 of those are filed across the United States per year, is what I heard at a conference. The estate income tax is a separate thing, and that is if you open an estate and you have an investment account, and suppose the estate remains open from January through November, and you make distribution, and you realize that the value of the estate went up by $20,000. If you have gain while you're holding the estate open, then you have to file an estate income tax return and leave that estate open until all those taxes are paid. So you might have to pay tax on that $20,000 of gain. It could be interest, dividends. It could be a rise in value. So, yeah, and I don't presume to know everything about those returns. And I think it's best for a state income tax return. I usually go to the accountant of the decedent who already understands the returns of the decedent. Also, while we're here, you want to make sure that you file the final personal income tax return if the person was income earning or elderly, because you never know when they're going to get some kind of a benefit or a rebate coming back from the government. So you definitely want to file a final return for the partial year that the person was alive if they're up to date on their income tax returns. And if they're not up to date, you might want to catch them up to date, because you can often capture some rebates. Let's see, sign the family. Step 9 is the accounting. This is what I was talking about in the very beginning, is that you can have a formal accounting in court. You can have a formal accounting between the parties, which is a kind of a very rigid format, or you can have a sibling put everything on an Excel spreadsheet and show it to the siblings, and the siblings can say, okay, I believe you, I'm signing off on it, it's fine. So you would have the siblings sign a family agreement or a release and refunding agreement. The release is you release the executor and you say you've done a good job, and the executors might want to hold back, say, $10, $20, $30,000 for a year to make sure all the taxes are paid. But you can release the executor for everything up to the $30,000 or whatever the reserve is. And then the executor do a little accounting in a year from then as the remaining assets. And then you distribute the assets, which is an important part. You don't want to miss that. And then you close the estate by filing a form with the Register of Wills, letting them know the estate is closed. You might ask the question, how many years do you get to administer an estate? Believe it or not, in Pennsylvania, 21 years. And even then you can keep going if you get special permission of the Register of Wills, 21 years. But you never want to take that long if you have beneficiaries who want to get paid. You have a duty to administer the estate promptly. And you want to try to do it within a year or two of the death of the decedent. It takes that long to know that all the claims have been filed and there are no outstanding liabilities and that sort of thing. So it's not a speedy process. You could distribute part of the money ahead of time. It's called a risk distribution, but you can do it if you're confident, if you believe there are no debts on the horizon or no lawsuits that are coming. Let's say determine who the beneficiaries are. Beneficiaries, an individual organization named in a will, and heirs are an individual who inherits under state law. That's an interesting definitional term. Most lawyers get that mixed up. So beneficiaries benefit from a will. Okay. Second notice of estate administration. Send the notice of estate administration form to the beneficiaries and the heirs. We did that. Notices, here's the time period, 60 days. So we're going back to the beginning. The notice of estate administration was 60 days. You want to file a certificate of notice with the Register of Wills. Here's more details about advertising. There's the notice form. I'm scrolling down. Sorry, I'm scrolling down in the one I have in front of me.
Yeah, you went backwards. It's okay.
I did? Oh, that happened. File the taxes, pay the debts. Oh, here are the debts. Here's the priorities. Can you go to that page?
Wait, hold on. I'm trying to figure out. I don't have that page on here.
It's like 4 or 5 from the bottom.
All right, hold on. What? Transfer, distribute. No, pay off. That's
right above distribute assets.
That's what I have. Pay off debts there.
Pay debts. Huh. No, it's called pay debts. It's 5 from the bottom.
Yeah, that's what I have. It's up.
Oh, yours got it. Yours must have been edited. Okay.
Oh, that's weird that we have a different one. Okay.
Yeah, you might. Don't not be on the same page. Anyway, so here's the priority. Anyway, I'll just read it to you. So administrative expenses, which they include. Oh, I forgot the all important thing. If you're administering the estate, you have a right to a commission, and the commission is something that's reasonable under the circumstances. And the cases have said that there are a few estates with these declining percentages, but just say roughly it comes out to being between 3 and 5% of an estate. If it's smaller, it'd be a higher number, under $200,000. If it's larger, it could come down to about 3% of an estate. So if you're administering an estate for $1 million, it could be you could have a fee. It's a lot of work, and you could be getting a fee of $30,000, and no court would challenge you on that. Okay, so it's important to remember that. Family exemption, that's rarely, and we'll leave that aside. Funeral and burial expenses, so you can always pay the funeral. They're way at the top, so you can comfortably pay the funeral even if it's an insolvent estate. You're okay. Then there's Medicaid medical bills for the past 6 months. I mentioned that. Then there's a grave marker. I had someone who designed his own grave marker and specified that it should be an obelisk made with made of marble, white marble, with carvings on each side. And my beneficiaries wasn't a large an estate, and the beneficiaries was a charity it was an orphanage in Israel, actually. And the problem is the grave marker would have taken away half of something like $70,000. So interesting case. What am I thinking of? The Secretary, not the Secretary of State, the Attorney General has a division that looks after charities, and we came to an agreement on a less expensive marker. You can pay the rent of the decedent, claims by the Commonwealth, other claims including credit card. So they're your lowest claims. And then don't forget to distribute the assets, what people are looking for. process is really this. You show an accounting of all the money that came into the estate, the money that was spent administering the estate for things like probate fees and advertising costs and your commission, the attorney's fees, maybe accounting fees, and then and payment of taxes, and then what's left, and then what the percentage is for each of the person. And this is really important. And if you're able to, if you're one of these people who's great with numbers and you can do it, without an accountant, great. Otherwise, you need to hire an accountant, perhaps a lawyer, especially if it's a large enough estate that people are going to be, complaining unless they have a really clear confidence that you've done a good job. A lot of it has to do with the relationship of the beneficiaries to the person administering it. The executor administrator can choose to take the commission, a portion, or none at all. That's a good point. You don't have to take the full commission. You can take a portion of it or none at all.
So Brian, I'm going to interrupt you because I know we only have 5 minutes left.
Great. Let's open up the questions.
And
I think we covered a whole lot.
I'm going to
Yeah,
I'm going to try to close out this PowerPoint.
okay.
I couldn't.
Sorry, I talked nonstop for a long time.
Yeah,
Anyway,
and I'm sorry, I couldn't see if there were any
questions?
questions in the chat.
I see Lucy has a question. Debbie has Lucy. We will send out today's oh wait, that's a PowerPoint.
You're good. Yeah, it's just
Okay, how are things different if there is a will and no non-probate assets? So if there's a will and if there's no non-probate assets, it means that all the assets are probate assets. And what's different is that you're responsible as the administrator for all the probate assets. So let's just take the example where you have a house and you have bank accounts in the individual name of the decedent. Then it's your job to liquidate all those assets and put the money into an estate account, do an accounting, and then distribute those funds. The more interesting question is, and I just had this in a state that was probably about $900,000, is what happens when virtually all the assets are non-probate assets, meaning they're beneficiary designation forms and accounts, and there's nothing left to pay the taxes. And it's an interesting question. In this case, there was one asset left, and it was the decedent's home, so that we have to wait until the home is sold in order to pay the taxes. But if there are no probate assets, then arguably, it's an interesting question. I don't know the answer yet, because that's coming up. It's coming up soon, coming to a court near you. I'm not sure what happens. Any other questions?
There's a question about where should the will be kept, right? And that's an interesting question.
That's a great question. So and I'm going to tell you a super quick story. I had a client I wrote a will for, and he was in the hospital. I went to Bryn Mawr and visited him, and I brought the will and I read him the will, and he gave $200,000 to his dear nephew, $200,000 to his next door neighbor, and the rest to, I will name it, University of Wisconsin, which is our alma mater. And when I read him the will, he said, "What? That neighbor, I don't want to give her any money." Or I might have read it to him and he said, "Please," I think it was, let's see, I'm trying to remember the sequence, but in any case, so I was leaving on vacation. I wrote a codicil for him, cutting out the neighbor. I went to my office before leaving for Jamestown, Virginia, wrote the codicil, faxed it to him, had him sign it, had his health aide sign it. He faxed it back to me. And then when I was away on vacation, he died. And I got back. And then his nephew notified his nephew. His nephew went to the house. But the neighbor also had the key. The neighbor who was cut out of $200,000. And wouldn't you know, we could not find that original codicil. So I explained the situation, and I tried to probate a copy, and the register in Delaware County says, "No, you can't probate this. It's a copy." If the decedent's holding the original of a will or a codicil and it's lost or it can't be found, it's presumed destroyed. But if an attorney or bank is holding the original, or a friend, and you can prove it, and it gets lost, you can still probate a copy. So what I've done ever since that case, and that was like 15 years ago, is I tell that story and I encourage people to have me keep the original, and I scan and email them a copy with a note saying, this is a copy of your will, I have the original. And that way, if anything happens, it increases the chances that their wishes will get carried out. So that's my answer. I think you should leave it with the attorney, but have them scan and or make a copy for you and hand it to you with a note saying original in my office. And that really increases your chances of getting your will, your wishes carried out.
Okay. Well, I want to thank you and thank everybody for joining. I know that we've had a few questions about the presentation. We will make it available in PDF to everybody. We'll send it out. I've taken some notes, so I'm going to edit it a little bit and then I will send it out. So Brian, I want to thank you so much. I am so sorry that I did not realize that you were sick. I hope you feel better and get well soon. And everybody have a wonderful Thanksgiving, and we'll see you.
Opportunity, and feel free to reach out to me if you have questions or follow up. I love to,
And we'll have Brian's information on the PowerPoint. We'll give your contact information, Brian.
Please.
Okay.
Thanks, Debbie. Thank you.